Justice denied again for the last two survivors of the 1921 Tulsa Race Massacre. And you're looking on the screen at those, at our last two survivors. Amazingly, Viola Ford Fletcher, Mother Viola Ford Fletcher, who is 110, and Mother Leslie Benningfield Randall is 109. She will turn 110 also later this year. They're the last two survivors of the massacre of our people, and estimated by some estimates up to 3,000 of our people. The standard number they usually give is 300, but up to 3,000 according to some estimates. They're still discovering graves, for example. On June 12th, the Oklahoma Supreme Court dismissed a lawsuit by survivors of the Tulsa Race Massacre. The plaintiffs sought reparations from Tulsa for one of the worst acts of violence against Black people in U.S. history. Per the Associated Press, the 9-member court upheld the decision made by a district court judge in Tulsa last year, ruling that the plaintiffs' grievances about the destruction of the Greenwood district, although legitimate, did not fall within the scope of the state's public nuisance law. I'll explain that, what that law is in just a minute, but I'm just going to go forward with what the lawyers for Mother Fletcher and Mother Randall said they will file a petition for a rehearing with the Oklahoma Supreme Court, asking the court to reconsider its decision. The lawyer's statement says the destruction of 44 square blocks of property on the night of May 31st, 1921, through murder and arson clearly meets the definition of a public nuisance under Oklahoma law. Faithful application of the law compels the conclusion that Mother Randall and Mother Fletcher have stated a claim for relief. They are entitled to a trial. Yet the court held that Mother Randall and Mother Fletcher have asked the court to decide a political question that is beyond the purview of the court. Incredibly, during the extensive oral arguments the Supreme Court held on the appeal, not a single member of the 9-member court asked a question about this political question theory. It is not a political question simply because the suit seeks to remedy wrongful acts perpetrated by a white mob against Black people. The court system is the very place where such harms are meant to be remedied. In 103 years since the massacre, no court has held a trial addressing the massacre, and no individual or entity has ever been held accountable for it. As justice is delayed once again in the Oklahoma court system, we call upon the United States Department of Justice, good luck with that, but it is an election year, so who knows, to open an investigation of the massacre under the Emmett Till Unresolved Civil Rights Crime Act of 2007. The massacre happened 103 years ago, but it remains a vivid memory of Mother Randall and Mother Fletcher, who as young girls saw their community destroyed in the worst act of domestic terrorism in United States history. As Mother Fletcher celebrated her 110th birthday last month, I think her birthday was on Mother's Day, I believe, or somewhere around that time, and Mother Randall will celebrate the same birthday later this year, time is of the essence for the investigation to begin. So they're asking for a couple of things here. For one, they're asking for the court to reconsider, and they are also asking for the Justice Department to intervene under the Emmett Till Act. Now, the lawsuit, this particular lawsuit, there have been several lawsuits, but this particular one here, which was led by attorney Demario Solomon Simmons, was filed when Mother Randall and Mother Fletcher were 105 years old. That they are still alive is just nothing short of a miracle when we stop and think about it. The city, this is what the lawsuit was saying. The city and insurance companies never compensated victims for their losses, and the massacre ultimately resulted in racial and economic disparities that still exist today. We're not just talking about what happened in 1921, we're talking about what's still happening, according to attorney Solomon Simmons. The lawsuit was filed under the state's public nuisance law of racial disparities oh no, the public nuisance law, which the state attorney general used to force opioid drug maker Johnson & Johnson to pay the state $465 million in damages. So they wrote this law, it's called a public nuisance law, and they were saying that these drugs, all of this drug addiction is a public nuisance for the state of Oklahoma. And so they filed a suit against Johnson & Johnson, and they won $465 million. And it just didn't cover the period of time when they filed the suit. It actually went back, I think, several years, for as long as the opioid crisis has been out there. The plaintiffs want the defendants to abate the public nuisance of racial disparities, economic inequalities, insecurity, and trauma for their unlawful actions and omissions caused in 1921 and continue to cause damage, over 100 years later. So that was the basis for the loss for this particular lawsuit that was filed in, I think it was 2019. They thought that if they took a different tack using the public nuisance law, that they might prevail, but the Oklahoma Supreme Court struck it down. Now, before that, there was this lawsuit that many reparations people thought was the case. If any case could win a reparations lawsuit, it was the lawsuit filed in 2003 by the famed law professor, Harvard law professor, and now ancestor, the brilliant Dr. Charles J. Ogletree. Okay, so this is from May 23rd, 2005. The Supreme Court last week declined to hear a case presented by Harvard professor of law, Charles Ogletree, that sought reparations for the victims of the cataclysmic 1921 race riot in Tulsa, Oklahoma. The case, Alexander versus State of Oklahoma, came before the court after the 10th Circuit Court of Appeals ruled in 2004 that it was too late for riot survivors and for their descendants to sue the state. The Supreme Court did not offer any comment on its decisions not to hear the case. Ogletree, who represented nearly 150 elderly survivors. So when he filed a lawsuit in 2003, there were still 150 survivors of the race massacre living. I'll tell you why this is important in just a minute. Let me finish with this. Ogletree said that the refusal by the Supreme Court was hardly surprising, but he emphasized that he still takes issue with the decision reached by the lower courts that argued that the statute of limitations had already passed in this case. The courts believed that the lawsuit could have been brought. This is Ogletree once again. The courts believed that the lawsuit could have been brought in the 1980s, and we believe it could not have been brought until after the evidence was fully discovered, referring to the 2001 report by an Oklahoma commission that investigated the riots and uncovered a lot of what we know about it today. And so Ogletree and his team of more than 400 plaintiffs filed a lawsuit in February of 2003. Now, all of us thought that the people who were involved in reparations, in the reparations struggle, thought this was the case for several reasons. One of the main reasons is because the argument that the United States power structure uses against reparations for the Africans who are the descendants of people who suffered under chattel slavery, were part of the Holocaust of chattel slavery, is that there are no living descendants. Now, this never applies, for example, to the Jews of Europe. The Jews of Europe get reparations, and their descendants get reparations. And Brother Amos and I discussed the French train case not too long ago, where Obama forced France to pay these people, some of whom were living in the United States, but they were not actual people who had actually suffered, under, what happened in Europe between 1933 and 1945. They were descendants. Okay. Here you have actual survivors. You had 150 actual survivors. And the Supreme Court said the statute of limitations, the lower court said the statute of limitations had expired, and the Supreme Court refused to even review the case. There are some cases, such as capital murder, for example, and the United Nations also said that there's no statute of limitations on crimes against humanity. But of course, this is the American empire, dominated by white supremacy. So what's just and what's ethical, doesn't matter. But, we thought, we have survivors, and they say, no, we'll find another angle. Okay, so now you have Mother Randall and Mother Fletcher. So now they're down to 2 survivors. And let's just be honest, they just playing this out until they die. And when they die, then they'll switch back and say, well, now there are no survivors. So, what I think about is how the United States in particular put pressure on Germany to pay reparations to the state of Israel. Okay, now they're not paying reparations to necessarily to the people who had to deal with the crimes by the Nazi regime, the Third Reich, during his 12-year reign. They're paying reparations to a state. It took power to force West Germany to pay. East Germany, which was then part of the Warsaw Pact under protection of the Soviet Union, never paid a dime. They couldn't force them to pay. They never paid a dime. As a matter of fact, Israel is still trying to collect money now from the unified Germany, that East Germany, then those who know the history after World War II know that Germany was split, between the Federal Republic of Germany and the Democratic Republic of Germany. One, the West, what we call West Germany and East Germany. West Germany became part of NATO, and East Germany was part of the Warsaw Pact. And so, but it was power that forced them. And so I'm saying that you may get a court somewhere that might at some point do something, but the basic way that you have to force justice upon people is power. That's just all there is to it. I mean, and these sisters have survived all of these years, and they're still being denied justice. And they're going to ask the court to review it. I know attorney Solomon Simmons is doing everything within his power. The great Charles Ogletree did everything within his power with his 150 survivors. And white supremacy prevails. It's almost as if Roger Taney, right, is still sitting on the bench ruling in the Dred Scott decision, because that's basically what they're saying. That's basically what they're saying is the same thing Roger Taney said in 1857. Black people have no rights that the white power structure is bound to respect. That's the essence of what they're saying. Okay. But it doesn't mean that we don't keep struggling. We just have to struggle for power, because that's the only way. You either have to have the actual power, or you have to have the power of influence. The reason why the United States was forced into a civil war is because Black people made chattel slavery. African people made chattel slavery the paramount issue in this country between the Missouri Compromise of 1820 and the start of the Civil War, right, in 1861. Our constant struggle. And yes, we had allies in some places like John Brown and his sons, but it was just a constant struggle that made it to paramount is you have to force people who just are simply are not going to just do what's right. You have to have power to force. And I say that this struggle for these reparations in Tulsa and other places continues, whenever these sisters transition to the spiritual world. And I hope that's not for another 10, 15 years. But it's up to us to just keep this in mind of what is necessary. But I nevertheless applaud the effort of Charles Ogletree. I mean, I remember just like yesterday when the Supreme Court handed down their ruling, because I was involved in the reparations movement, and I said, this is the case. What are they going to say? What are they going to say? We got survivors. What are they going to say? Statute of limitations. It's always a game. So I just wanted to bring that to the attention of our family, Brother Amos.
In comparison, look at what they did for the Sandy Hook family survivors. They gave them almost $1 billion from Alex Jones for something that he said.
Just something he said.
Versus you have here survivors from family members who were killed, and they don't want to give these black people reparations. And like you said, it's all based in when there's a white power structure, they can make or break the rules. And this is one of the reasons why Garvey said, let's go back to Africa, let them have America.
Exactly. We got to go back then and overthrow neocolonialism, but at least we have the numbers working for us. If we can convince we can raise the consciousness, we'll have the numbers.
And brothers and sisters, leave your comments down in the comment section. Like, comment, and subscribe. Be before the A.
Be before the A.